Amendment by Collier.
Chair recognizes Representative Collier. The amendment is temporarily withdrawn. Following amendment, clerk will read the amendment.
Amendment by Howard.
Chair recognizes Representative Howard.
You go already, do rock and roll already?
Thank you, Mr. Speaker. Members, this amendment is actually in regard to the admitting privileges transfer procedures. The way that the bill is worded, it requires that hospitals have active admitting privileges. What currently exists in abortion clinics is that you have to either have, the physician has to either have admitting privileges or a written transfer agreement. What currently exists, that's for the ambulatory surgical centers. What currently exists for the abortion facilities is that you either have to have admitting privileges or have a working arrangement with another physician who has admitting privileges. You do have to have an actual protocol in place. This is part of the regulations, a protocol in place for dealing with the medical emergencies and transfers. That's what currently exists. This bill says that we want to have the abortion facility, which would become an ASC, have to require the physicians to have active admitting privileges. That is above and beyond what currently exists for ASC. So this amendment would bring the transfer requirements of abortion facilities in line with what currently exists for ambulatory surgical centers. Title 25 of the Texas Administrative Code requires an ambulatory surgical center to have the written transfer agreement with the hospital or the physicians on staff to have admitting privileges at local hospitals. So in keeping with this bill's intent to require abortion clinics to be regulated as ambulatory surgical centers, this amendment would apply what currently exists for ambulatory surgical centers in terms of their transfer admitting privileges guidelines to the abortion facilities. Many physicians operate clinics and provide services at those clinics, but do not have admitting privileges. No other outpatient procedure requires a physician to have active admitting privileges, certainly not within a specific distance. This is opposed by the Congress of Obstetricians and Gynecologists. This is a compromise I'm trying to come up with here that honors what I think the intention of the author of the bill is, and that is to require abortions to be performed in ambulatory surgical centers. There is no reason to change the admitting privileges requirement to something that's other than what currently exists for ambulatory surgical centers. So that's essentially what this amendment does. And I yield to questions.
Madam Speaker?
The gentlelady yields.
Thank you. And Representative Howard, why exactly is this amendment necessary?
Well, actually, I think one of the reasons that it's necessary is because, well, for one thing, we're requiring something that's completely different. It's not something that needs to be done. It's overreaching for something that is not currently in place. This would bring the agreement under the standards that currently exist for the ambulatory surgical centers that are found in the current administrative code. And as I said, since we're holding the abortion clinics up to the practice of an ambulatory surgical center, the standards, the regulations for ASCs, for hallway width, for operating rooms, for janitorial closets, for all of the facility changes that occur in an ASC, why would we not also have the abortion facility that's now a part of an ASC meet the current standard for transfer and admitting privileges? It just makes sense to make it the same thing.
So therefore, what is this concern addressing?
There's actually a concern about how this will impact the ability of physicians at abortion facilities that become ASCs to gain admitting privileges. The fact is that there is some concern based on how admitting privileges are given and renewed, that whether or not these physicians would qualify at this above and beyond standard. At least with the standard that we're proposing here that is currently in existence for an ASC, there is a possibility of having a transfer agreement with the hospital.
Okay, and why would a hospital be unwilling rather, to grant admitting privileges to a physician?
I actually have a copy of the statement of the testimony that the Texas Hospital Association gave.
I'm sorry, Madam Speaker, I'm having difficulty hearing Representative Howard. May we have some order in the House?
Members, if we could please have some order in the House. If you have a conversation, please take it outside the rail so that the members can hear each other.
Thank you, Madam Speaker.
Thank you. You were asking about...
Yes, why would a hospital be unwilling to grant admitting privileges to a physician?
What I have is a copy of the testimony that the Texas Hospital Association gave when they testified in regard to this bill. And one of the things that's stated in their testimony is that if a physician does not perform any procedures in the hospital or performs the procedures that the hospital does not perform, there is no process for the hospital to grant privileges to that physician. Thus, if the hospital does not perform elective abortions, which THA has said that there are no hospitals that perform elective abortions in Texas, so if there is no hospital that performs elective abortions, the physician seeking privileges to perform abortions would not be granted those privileges. I mean, this is a circuitous thing we're talking about here, but the bottom line is you can't get privileges for a procedure that the hospital doesn't perform, and if the hospitals don't perform elective procedures and that's what you're seeking privileges for, you will not get privileges.
So it's a catch-22, if you will.
Absolutely.
And you know, one of the things we discussed, and I think you mentioned this in your layout of the amendment, you mentioned a distance issue. And so if all hospitals within the required 30-mile radius were denied admitting privileges, can you speak a little bit about that?
If all hospitals were denied, I'm sorry.
If there's a 30-mile radius requirement, are you familiar with that?
Yes.
Can you speak to that a little bit?
Well, one of the things that I learned in talking with some of the obstetricians and gynecologists that are very concerned about this bill is, for one thing, if they had privileges at a local hospital that was within a 30-mile radius, and yet they have a patient who travels from 100, 200, even more miles away to come to their future ambulatory surgical center to have the procedure, even if they have privileges within their local community, when the patient goes back a couple of hundred miles away to their home, their instructions are going to be given is if they incur some kind of a complication later on, that certainly they need to get to an emergency room, and they are going to go to the emergency room that's in their local community. They're not going to come a couple of hundred miles back to the hospital where this particular physician might have privileges.
And so, in your opinion, as a nurse, would that place an undue burden on individuals, for example, living in distances, for example, in far west Texas or in the lower Rio Grande Valley, where they may not have access?
Absolutely. I mean, the fact is that whenever anyone has an emergency situation, a complication for any kind of surgery that they might have had, it doesn't have to be an abortion. You have a complication. You go to the emergency room. You don't typically think, gosh, does my physician have admitting privileges at this hospital? I'm going to go to the emergency room that's closest, that I feel comfortable going to, whatever my criteria are, but I'm going to get to that emergency room, and I will be treated there. You do not have to have admitting privileges for a patient to be treated in an emergency department when they present.
Okay. And let's talk briefly about, have you driven across the state lately, either from Austin to El Paso, or from Austin to Laredo?
It's probably been a couple of years now that I've driven to El Paso.
Okay, but you are familiar about, what approximately a tank or a gallon of gas costs?
Certainly, yeah. I mean, depending on the type, as I heard someone say previously, the type of vehicle, but certainly it's going to probably take a couple of tanks of gas.
You're right. It does. It takes about at least 3 tanks of gas to get from, or at least 2 tanks of gas to get from here to El Paso, and it's approximately a 8 to 10 hour drive, depending on if you're going to obey the speed limit or not. And do you know approximately how much the flights are from here to El Paso if you get a fairly good deal on Southwest?
Well, the last time I checked, I think I was looking at something that was around $150.
That's right. It takes either between $150 or $300, depending on, and that may be just a one-way, or depending on a deal, you can get that maybe on a round trip. But it's not cheap for an individual. But let's go back to some precedent regarding some of the scenarios that we've discussed. Can you talk to me about the state of Mississippi and the sole abortion clinic that they have, and the similar law that we are proposing here today?
Well, and I know we had some back and forth a while ago on this issue, and from some lawyers, which I am not, but just from what I understand and what I've been reading about it, Mississippi, the state's sole abortion clinic was faced with a law similar to the one being considered here today, and the clinic made requests for admitting privileges to hospitals in its surrounding counties and were refused based on administrative issues unrelated to the doctor's qualifications.
Representative Stickland raises a point of order. The gentlelady's time has expired. The point of order is well taken and sustained.
Move for